welcome to Litigation Help. My name is Heather Twin, and joining me here is Heather Douglas. Hi, Heather.
Hi.
Our video today is on the word equity. We often come across phrases like law of equity or equitable remedies. So Heather, what do these terms mean?
The important term I'm going to discuss today is equitable remedies. Equitable remedies refer to remedies that are non-monetary. And an easy way to say that in plain language is not money. And the common equitable remedies that people ask for include specific performance, injunctions, a constructive trust, and rescission of a contract. There are a whole bunch of what I will refer to as special remedies that aren't money that people can ask for. But the default is to ask for a monetary remedy, is to ask for money. An example of someone who might ask for a special equitable remedy can be seen in real estate law. Commonly, every day, people buy and sell houses. And right now, the market is going up and up and up. So what happens if I buy a house and then the seller decides, no, I don't want to sell it anymore to you. I saw that the prices went up even more 2 weeks later, and I want to put it back on the market and sell it to someone else and get more money. Can they do that? What kind of remedy should I ask for? The law would say that you can ask for damages. You can ask for a monetary remedy. You can say, well, I want my money that I gave you for my deposit back, or I want some kind of financial resolution. In some cases, you might ask for what's called specific performance. You might say, you know what, I'm going to go to the courts and I'm going to ask a judge to make an order that you have to sell me this house. You can't put it back on the market. No amount of money you give me will make up for this loss. I need to have that exact house. What would be an example of a case that it would well be suited for specific performance? Not every case is something where the court will want to give specific performance because it's a special remedy. The default remedy is always monetary when it comes to common claims. An example might be, I live in rural Ontario. There's only 5 houses in this area that I'm buying into. I need to live there for work. The other 4 houses aren't on the market. And I can't just go live anywhere. And this land and this house is so special and so unique that no amount of money will make me whole again. I need the court to order this person to sell me their house. And that might be a case where you would ask for specific performance.
So Heather, and this great example that you gave, the person suing, they would include in their statement of claim that they're suing not only for damages, but for specific performance. Like it's in the statement of claim, right?
Yeah, you have to put in, or it could be an application, depending on the legislation that you're suing under. You have to ask for your special remedy, your equitable remedy. And if you want, you can ask in the alternative for damages, like for monetary relief. The default is always asking for monetary remedies, always asking for money.
Right.
But let's say you have that special case for that special house.
Yeah.
Then you're going to ask for that equitable remedy first. And then say in the alternative, if for some reason the court finds that you don't fall under the unique set of circumstances that allow you to get that equitable remedy, then, okay, well, I would still like to have my money.
And just for a final question, is it important to know whether a remedy is equitable versus regular?
Yeah, it is, because not every court or tribunal you go to can give you an equitable remedy. The Superior Court of Justice, they can give equitable remedies. But if you look at many tribunals, their legislation that gives them their jurisdiction doesn't allow them to go beyond the remedies listed in the legislation. So many places can't give you an equitable remedy. And similarly, in small claims court, they can only award certain types of damages and up to a certain amount of money.
Hey, Heather, just this is, I promise the last question, it just came to my head. Yeah, because this small claims court example you gave is interesting, because how would a person know where is this information written that you can find out? Yeah.
It's in the Courts of Justice Act. And then I think that there's also a regulation under the Courts of Justice Act as well that provides information on limits. But the Courts of Justice Act sets out the jurisdiction of a small claims court.
Oh, brilliant. So for the viewers, I will have a link in the description below for the Courts of Justice Act. And Heather, oh, that was a great explanation. Thank you so much for that. And thanks to everyone for watching again. If you found this video helpful, we'd appreciate it if you give it a thumbs up and also share it with your friends. And if you've not already done so, please subscribe to us so that you won't miss out on our next videos. And thank you very much. We'll see you the next time. Bye.